What are bills with a public's right of access disclaimer? If you've ever read a bill, you might find a section at the very end discussing the public's right of access being limited by the bill. What does that mean? Well, let me read you the language that you would find in a plus section at the end of the bill. It's uncodified language. And it says the legislature finds and declares that Section 1 of this act, which amends Section 12651 of the Government Code, that's an example, imposes a limitation on the public's right of access to the meetings of public bodies or the writings of public officials and agencies within the meaning of Section 3 of Article 1 of the California Constitution. Pursuant to that constitutional provision, the legislature makes the following findings to demonstrate the interest protected by this limitation and the need for protecting that interest. Sensitive information of California taxpayers should be adequately protected from disclosure during the process of the assessment and collection of taxes to protect privacy and increase compliance. So why is this language required to appear? We have to turn to naturally Article 1, which is the Declaration of Rights of the California Constitution, which is referenced in this plus section language. And we look at Section 3 of Article 1. Section 3 of the state constitution provides that the people have the right to instruct their representatives, petition government for redress of grievances, and assemble freely to consult for the common good. In addition, this section states that the people have the right of access to information concerning the conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. Now, Section 3 also specifies that a statute, a court rule, or any other authority, including those in effect at the effective date of this new subsection, are required to be broadly construed if it furthers the people's right of access, and narrowly construed if it limits the people's right of access. Furthermore, it says a statute, court rule, or other authority adopted after the effective date of this subdivision that limits the right of access is required to be adopted with findings demonstrating the interest protected by the limitation and the need for protecting that interest. And so it's this sentence that's key to answering our initial question about why these bills have a disclaimer. So this provision of Section 3 of Article 1 requires a statute that limits the right of access of the public to be adopted with legislative findings that make it clear what the interest is that's being protected by limiting the public access. And the language also has to justify the need for protecting the public's interest. Section 3 contains other language, such as that the provision of law does not supersede or modify any constitutional provision, including the guarantees that a person may not be deprived of life, liberty, or property without due process of law, or be denied equal protection of the laws. In addition, Section 3 includes a provision that nothing in this provision of law repeals or nullifies, expressly or by implication, any other constitutional or statutory exception to the right of access to public records or meetings of public bodies that were in effect as of the effective date of this new law. Finally, Section 3 requires each local agency to comply with the Public Records Act and the Ralph M. Brown Open Meetings Act. So if we return to the initial question I posed, similar to the findings required for bills like that contain urgency clauses or are deemed special statutes, the legislature has to adopt a finding that justifies the bill's language that would limit the public's access to public meetings or writings in order to comply with Section 3 of Article 1 of the state constitution.